Welcome to a Practice Pro CPD, brought to you by LAWPRO.
Good morning and welcome to our program. I'd like to thank you all for attending today and my great panel here this morning, which includes my colleague, Michael Cortez, and our preferred counsel, Dan Zacks and Ted Morocco. I see now that our host has joined us as well, so I'll turn it over to Sean. And again, thank you for attending this morning's session. Sean, I'll turn it over to you now.
Thank you so much, Katie, and I apologize. I had some technical difficulties right at 9:29, which is always the worst time that you want it to happen. But I just want to come in and Katie, just to confirm, have you done a land acknowledgement?
No, I was just doing the opening remarks. So
all right. Well, then I'd like to introduce myself. My name is Sean Erker. I'm the legal writer and content manager at LAWPRO, and I'm going to start by acknowledging that I am doing this presentation in Toronto, which is also where the offices of LAWPRO and the TLA are located. And I want to acknowledge that it's the traditional territory of many First Nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and it's now home to many First Nations, Inuit, and Métis peoples. It's covered by Treaty 13 with the Mississaugas of the Credit. As this meeting is virtual, not everyone will be in the same space, so I encourage you to look into the traditional territories that you are on and find out more about the history of that land. As a resource, you can visit nativelands.ca, that is native-lands.ca, to search a location and find out more about that. So as Katie said, thank you all for joining us for this. It's the 2023 edition of our Top Tips for Advocates program. It's presented by LAWPRO and the Toronto Lawyers Association. So I want to thank Deirdre and Sandra and everyone else at the TLA for assisting us with them. As Katie said, I'm joined today by Michael Cortez, counsel with LAWPRO, Ted Morocco, partner with Stockwoods LLP, and Dan Zacks, principal with Zacks Law. So we have some excellent experts here to talk about this program. We also have some written programs that are available, written materials for the program that are available online at practicepro.ca/CP, and I'm also going to put them in the chat for this program right now, so you can find the material, download them, and follow them along. There are some articles that cover the topics that we will be discussing. A couple more housekeeping matters. I also want to remind everyone that the TLA will be sending out a survey after the program, looking for your input on what you liked and what you didn't like about the program. We strongly encourage you to fill out that survey because it helps us prepare better programs in the future. So we encourage you to take a few minutes to do that. If you have any questions about the program, you can put them in the Q&A box, which is part of the Zoom software. And I will be keeping an eye on that, and we will try to get to the questions. If we don't get to them through the program itself, we'll try to get to them at the end if we have enough time. Now, we're going to be talking about 4 different things for advocates today. Sorry, just making sure that I don't have any more technical problems. The subtopics that we're going to be discussing are limitation periods, which gets into some time management tips, file management and organization, technology, where we're going to be talking about both breaches of privacy and new tech like AI and the claims risks that are associated with that, as well as doing a general overview of the kind of claims that we are seeing at LAWPRO. And we're going to start with that general overview of the claims we're seeing at LAWPRO. And so I'd like to hand this off to Michael Cortez, who's going to start with that topic right now. Thank you so much. Michael?
Good morning, everyone. I can be heard. Excellent. When I was in law school, I remember having a dinner with one of our practitioner professors many moons ago, and someone asked him, how many years of practice was it before you stopped looking over your shoulder and every move you made? He said, maybe 4 years, maybe 5. He thought about some more and he said, maybe never. So in that spirit, I'm going to talk about all the latest and greatest ways you can still look over your shoulder in deep justifiable paranoia. I'm going to try to sort of do this like a top 10 list, but then I'll stop when I start to run out of time. But before I do that, let me just make one footnote. I need that disclaimer that appears in the jacket of paperback novels. Any resemblance to persons living or dead is purely coincidental. I'm not invoking any specific person as a cautionary tale here. Every item I'm going to talk about today comes from a large grouping of many incidents. That's why it's on the list. If this does sound familiar, know that you're in a very big club. Rest assured, it's not about you. But for the grace of God, go the rest of us. We've all been there. So the number one item was a headline grabbing type error for 2022, and that is judicial stays arising from partial settlement agreements. This was the revival of the ACON line of cases. And if I'm speaking Greek to you, let me give you the Coles notes of the scenario that arises. What happens is a plaintiff enters into a Pieringer agreement or a Mary Carter agreement and settles with one defendant intending to continue on against another defendant, but the plaintiff does not disclose it to the remaining defendant. And then at a later date, the defendant finds out about it. Then they bring a motion to stay the entire action against them on the basis that the lack of immediate disclosure is an abusive process. Based on the somewhat new or old and very favorable case law from the Court of Appeal, the defendant may very well win that motion. And if they do, it's now a solicitor's negligence claim because the entire action is dead in the water. Now, I've heard some rumblings that the Rules Committee is trying to work out a comprehensive system as to what lawyers are going to be required to do and when. So in the future, we're going to have a lot more of that step-by-step guidance that we crave. But until then, just know that this is a danger zone. If you're going to play around with partial settlement scenarios, particularly any kind that has a fancy name that got imported from the US years ago, you're going to want to be asking, what are my obligations and what don't I know? So number two is practicing in other provinces. And of course, that's not an error per se, but it's a phenomenon that's on the rise that is giving rise to new kinds of errors. For example, if you don't know what the drop dead rule is or what the fresh step rules in Alberta are, in my view, you probably shouldn't be practicing in Alberta without co-counsel. Nowadays, we've got mobility treaties, which make it a lot easier to practice in another jurisdiction. And that's a good thing. And then post-pandemic, we have the acceptability of Zoom, which has made it a lot more practical and cost-effective to practice in other jurisdictions. And that's all great, but people need to be mindful that you don't know what you don't know. And not all rules of civil procedure are created equal, in my view. And in fact, in my very, 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 very biased view, certain aspects of Alberta civil procedure are pretty draconian at times, at least compared to what we're used to. And again, in my biased view, I find defense counsel in Alberta will love to string Ontario plaintiffs along with protracted settlement negotiations while some of these surprise deadlines are ticking away, particularly the 3-year fresh step requirement. A lot of Ontario practitioners think they know what constitutes a fresh step, only to learn it's not really what they thought it was. And these are tough motions to win out in Alberta. And so I think you either need to be educated on the finer points of Alberta's rules or just co-counsel like we always used to do. Anyways, we're also seeing a rise of claims in Nova Scotia for some reason, though I haven't actually seen anything specific to Nova Scotia that made me fearful or anything that I would flag. Number 3 on the list. This one will hopefully die out soon as it'll apply less and less over time, but it's miscalculating the pandemic legislation extension. We've got a really big club of practitioners who just added 182 days onto their diaries. And that works, I don't know, 80, 90% of the time. But of course, with your luck and my luck, it won't work for your file. So it's not the way to go. What you need to appreciate, so I think everybody knows at this point, the suspension was retroactive to March 16, 2020, and then it continues all the way through to September 14, 2020. And yes, that is 182 days. But if your limitations clock starts ticking in the middle of that time period, say that's when your discovery occurs, that means you don't have the full 182 days. You only get the amount of time between when your clock starts ticking and that September 14, 2020 date. So what I usually suggest to people is Google LAWPRO limitations calculation or some kind of variation of that. Usually the first link that's going to come up is a December 21, 2020 article. It's called Tips for Calculating Limitation Deadlines Accounting for the COVID-19 Emergency Suspension Period. And it shows how to calculate the extension for pretty much every scenario. You just kind of run through it and say, yeah, that's my case. This is how you do it. So I feel like since Dan Zacks is here, he would caution me to say, why are we even relying on this in the first place? We should be diarizing for 2 years or whatever your limitation period is. We shouldn't be relying on this at all. But if for some reason you have to, you can get help with that calculation because it's not a simple one. Number 4 is a classic hit, admin dismissals. And pre-pandemic, admin dismissals was probably one of the largest sources of solicited error that we would see at LAWPRO. And that's even before we get to its cousin, the contested status hearing. But as you're probably well familiar with, most registers have stopped issuing dismissals, which on the one hand, depending on your own personal biases, has probably been great. But if your practice is defense-oriented, it has been particularly annoying. And at LAWPRO, we do a lot of defense-oriented files as well. And one of the phenomena that this has caused is it's given rise to an unusual spike in dismissal for delay motions as counsel are really sort of looking around for what tools can I use to get stagnated cases moving again. That motion has a much different test, though, and it's harder to succeed on in my view. But the real concern that I wanted to flag is that there's nothing that stops a registrar from turning on the admin dismissal tap whenever they want. There's just nothing that prohibits them. And in different courthouses, some actually have, and then stopped again and started again. And there's really no, from our perspective, there's no rhyme or reason to it, though I'm sure there's lots of important reasons that drive it. So the point is, we've got to be ready. The bottom line is, you've got to be diarizing your 5 years. It might be that the court or the province is going to come out with an official statement and we'll have a warning period to get ready, but there may not. So know your set down dates and your timetable deadlines. Number 5, this is proceedings against the Crown Act notices. This is kind of making a resurgence, and I'm not really sure why. Maybe it just followed from the updated legislation, but I doubt it. When I was an articling student many moons ago, one of the lawyers I worked for explained it to me like this: if you're the government, of course you're going to make special laws to make it harder to sue you, and they did. But regardless of whether you actually buy into conspiracy theories or not, before you can sue the Crown, you have to appreciate that there's a special set of rules, and principally among them is that you have to send a written notice with special criteria, and then after you send it, you have to wait 60 days before you can issue a claim in that after that 60-day window. If you don't, the Crown gets to move to kill your action as a nullity, and that comes from Section 18 of the Crown Liability and Proceedings Act. The scenario that seems to come up with us at LAWPRO a lot is we have a lot of people who are jammed. They see that 2-year deadline coming and they panic and they figure that missing the 2-year limitation would be the greater evil. Not so. That notice is paramount. So if you are actually up against your 2-year deadline, what you want to do is you want to issue that notice and you want to rely on a more obscure section, Section 18 sub 3 of that same act, that provides that the act of submitting the notice will extend the 2-year limitation. And that'll give you more time. But then you got to really be on top of things because you got to be able to issue right after. So this legislative regime continues to vex practitioners, and people should just really be mindful of that 60-day hold requirement. Maybe I can fit in one more here. Number 6, missing the 6-month deadline for service. This is another classic hit that has bizarrely exploded over just the past couple of years. My personal theory is that it's because of the lack of admin dismissals. Defense counsel is putting their procedural energy here, and they've just stopped consenting. The good news is it's still a relatively easy motion. Absent terrible facts, LawPro and plaintiffs are winning these at a really good clip. Absent real and substantial prejudice, my view is the courts just want to get the action on to adjudicate the merits. But diarize that 6 month and save yourself the headache, because so many people are just letting it run through and then bringing a motion after, expecting it to be routine, and then discovering that defendants are really taking a hard line. Oh, and don't forget, this is a big piece of this. The 6 months, yes, the 6 month runs from the date of the statement of claim being issued, but if you do a notice of action, it now runs earlier from the notice of action, not from the statement of claim that follows. So we get a lot of people who wind up being a month late with their service. That's found in Rule 14.08 sub 2. Very understandable error, but we see it a lot. I just want to add that notice letters really help here. It's very hard for the defendant to show any kind of prejudice when they got a letter alerting them to the fact of the impending claim, in particular if an insurer was contacted. So great work, everybody. Keep doing those. Those have been saving our bacon. And I think I'm probably running out of time. So maybe I'll see if Katie wants to jump in.
Great. Thanks, Michael. A few more tips and quick files that we're seeing here at LawPro is getting off the record issues. I've seen a number of these come in where you're served with materials because the court has not seen that you've gotten off the record. While you may be served with the notice of change, I encourage lawyers, and I know it's work, but I encourage you to check the court file to make sure that the court actually has you as off the record. Otherwise, you find yourself in that awkward position where you're served with materials. We see a lot of noting in defaults. These are arising simply from failure to timetable or calendar properly. So we're seeing those come in quite regularly, and we encourage you to, and we'll talk about it more in file maintenance, to make sure you're keeping accurate dates and timetables. Speaking of timetables, we see those too. We see a lot of failures to meet timelines. Again, it's just an issue of having to make sure that you have docketed and set out calendars to make sure that you know the timetables that you're meeting. Another one I've seen quite a few of recently is fail to respond to requests to admit. So either they're missed or they come in an email and you don't realize it's attached, those sort of things. So make sure you're on top of those. And lastly, a failure to answer undertakings. We're seeing quite a few of those as well. How can these sort of things be avoided? Pay attention to detail. Stop and thoroughly review your files. A high volume practice is a big risk factor in these types of errors. Know your files, review them regularly, and do adequate investigation. Another tip I have for you is review the law. Don't take for granted that you know it. Check on things, look at legislation, make sure you're aware of changes. And a final tip I have is make sure that you read and you're aware of the most current notices to the profession. The courts expect you to be aware and comply with the notices to the profession as of the date they were issued. Now I'll turn it over to Sean. Sean?
Thanks so much, Katie, and thank you, Michael, as well, for that summary of the types of claims that we've been seeing recently at LawPro. Moving on, our second subject of the day is we're going to be talking about limitation periods and time management, and I am going to send that to Dan Zacks to speak about, which is excellent because Dan has written, he's the co-author of The Law of Limitations, the LexisNexis textbook on the subject. As well, he runs a blog called Under the Limit, so he's the best person to ask. Dan, what do we got to know about limitations?
Thank you, Sean. The first point I want to make is I want to echo a point that Michael made about the dangers of practicing in other jurisdictions. People assume, I assume that limitation statutes in other provinces are basically the same as they are in Ontario. They are not. You must be very, very careful about ensuring you understand the limitation schemes in other provinces. Sometimes they can be completely different, like in Newfoundland, where it's mostly an old style limitations act, like the one Ontario had prior to 2004, but with some quirks. Nova Scotia looks somewhat like ours, but the application of the discoverability principle there is much narrower. And worst of all is you get limitation periods that are not in the act, and you might not even think to look for them, and that causes all sorts of grief. Like, so for example, if you're going to sue the police in Halifax, there is a limitation period in a statute that deals with Halifax municipal issues, and you know, if you don't know about that, you are going to get yourself into trouble. So always read the Limitations Act of the province you're about to practice in. It will make life better for you. Michael also touched on the COVID suspension. I think he explained it very well. You know, if you deal with the suspension a lot, it becomes reasonably straightforward. But if you're coming to it infrequently, as most of us are, then it's kind of arcane. So I would encourage you to do exactly what he said. Use an online calculator to add the 182 days or however many days that you need to add. And if you the regulation, it's Ontario Regulation 73/20. It's pretty easy to read. It's short, so you can always go there and you know, with little effort, you'll explain yourself. Mostly, it's not so relevant now. It's usually people who have miscounted in the past, but like if you were starting a new action or did start a new action in the last, well, really in this year, it doesn't apply. So, you know, in time, it will be just a memory. I wanted to talk about the ultimate limitation period, because that's something that I see people forgetting about, both plaintiff and defendant. It arises, the ultimate limitation period in Ontario, you got 15 years to sue from the date of the loss. Whatever the actionable conduct is that gives rise to your claim, you got 15 years from that date, and it commences always on that date. Discovery doesn't apply. And there are very narrow circumstances in which the limitation period will be suspended. It's basically fraudulent concealment, which the Act describes as willful, how to put it, willful concealment and like misrepresenting the fact of the claim. I'm not sure I've ever actually seen a circumstance of that. And then circumstances where the plaintiff is a minor or lacks capacity. It's most frequently an issue in circumstances, in actions based on contracts that were drafted more than 15 years ago. So like happens in the matrimonial context, it happens in the estate context, and often when lawyers have drafted an agreement and the effect of the agreement is felt more than 15 years later. People expect that they will be able to hold their lawyer account for a mistake made with the agreement, but more than 15 years have passed. That is not something that plaintiffs can do. Plaintiffs do not appreciate that, and defendants don't necessarily recognize that they have an ultimate limitation period defense. There's been an interesting development in the last few months where the Court of Appeal has looked at the suspension provisions as they deal with capacity and being a minor. And there was this idea that if at some point during the period between the act that gives rise to the claim and the date that the plaintiff wants to sue on it, their plaintiff was under 18 or without capacity, it would, in all circumstances, suspend the limitation period. And so I was seeing circumstances where people would be like, can I come up with any sort of incapacity during those 15 years, particularly if you only needed to buy a few days? Yeah, like, I don't know, maybe you were in the hospital for a few days during those 15 years. And we get turning into these really strange analyses where you'd have to look at medical records and try and come up with time. And I was getting ready to argue in a matter based on a building permit that a municipality had issued in the 80s, that just because a plaintiff is under 18 for some portion of the time between when the actionable conduct occurred and when the plaintiff sues doesn't trigger these suspensions. It's absurd. And unfortunately, somebody else got to it in exactly the same back scenario before I had my opportunity. It's and the Court of Appeal held that the suspension provisions only apply when the cause of action arises during the time that plaintiff is a minor or without capacity, which makes total sense. It's not really what the language of Section 15 says. I suspect the legislature never really considered this issue when they were drafting it, but it makes a ton of sense. It's a very good decision. And so just be mindful that if you're going to try and rely on these suspension provisions, they only apply when the plaintiff has the cause of action. So, in the case of a municipal building permit, the cause of action that arises when you buy a house, there was some permitting issue, you have to have bought the house in order to have the cause of action. If you were a minor or without capacity before you bought the house, it doesn't have any impact on the running of the ultimate limitation period. And I also like to talk about proceedings against the Crown. As Michael noted, this is something that is an increasing issue. People who do not often sue the Crown are sometimes unaware of the notice requirement, but it's not just the notice requirement. There is a leave requirement as of 2019. So what is this leave requirement? In Section 17 of the Crown Liability and Proceedings Act, basically it creates a requirement such that you need leave of the court to sue the Crown or a Crown employee for misfeasance in public office or another tort based on bad faith. This provision was challenged as being constitutionally invalid, and until mid-March of this year, the Crown was, to my knowledge, waiving its application. So if you had not brought a leave motion, that was not going to be an impediment to the action. But then in mid-March, in a decision styled Poor Kid Investments and Ontario Solicitor General, the Court of Appeal upheld the validity of Section 17, and since then, the Crown has been enforcing the leave requirement. So if you were going to sue the Crown or a Crown employee for misfeasance in public office or some other tort based on bad faith, you need to bring a leave motion. And unless leave is granted, the action is deemed stayed. In order to obtain leave, you have to establish that the plaintiff is bringing the proceeding in good faith and that there's a reasonable possibility that the claim will be resolved in the plaintiff's favor. The evidentiary requirements of the leave motion are set out in Section 18. And so if you are going to sue the Crown or a Crown employee, I encourage you to read the section to make sure you understand what's required. And then there is the classic notice requirement for suing the Crown, which exists to create pitfalls for lawyers. I don't think you need to be a conspiracy theorist to appreciate the strong incentive the Crown has for discouraging litigation against it. And this is one of the ways that it accomplishes it. So you got to give the Crown 60 days notice. That means you cannot sue until 60 days have passed from the date when you give the Crown notice of claim. The notice must contain sufficient particulars to identify the occasion out of which the claim arose. The idea is that you want to give the Crown sufficient information so that it can investigate the basis of the claim and give it an opportunity to resolve that basis. I don't know in practice how often giving notice results in fruitful settlement negotiations, but that is sort of the policy rationale behind it. If you do not give notice, the action is a nullity. Statement of claim can, in certain circumstances, satisfy the notice requirement. And as Michael said, there is a provision in Section 18 which helps you in a circumstance where the limitation period expires after notice is given. So if the limitation expires after notice is given, the effective notice will extend the limitation period until 7 days after the notice period expires. So if you are choosing, as Michael said, between satisfying the limitation period, between commencing the action in time or satisfying the notice requirement, always go for notice. There is a shorter notice period as well. If you are suing the Crown for a breach of a duty respecting property, generally occupiers' liability matters, the notice period is 10 days commencing on the date of loss. So it's the same notice concept that you get in municipal acts. If you're going to sue on a slip and fall or something of that kind, you have to give the Crown effective notice within 10 days of the loss, otherwise a nullity. And with 4 minutes to go, those are the topics that I wanted to touch on.
Thanks so much, Dan. So moving on now, what I want to do is I want to ask all of our speakers to turn on their camera, because I'm going to go around and I'm going to ask each of the speakers what their top tip is for time management or for managing limitation periods and avoiding any claims associated with limitation periods. So Dan, I'm going to start with you. What's your top tip for that?
Always sue within 2 years of the loss. Discovery arguments are possible, but very uncertain. Avoid them as much as possible.
Excellent. Michael, you're next. What's your top tip?
Sometimes some people diarize for admin dismissals at the 5-year mark because that's your set down date. And if you're able to set down your action immediately, that's great. But otherwise, 5 years as a diary is too late, because the rule provides that you can get a consent timetable in, but you have to do that 30 days before the dismissal date. Otherwise, you need the dreaded status hearing. So you need at least 30 days. And as a practical matter, you need much more than that, because you need time to get opposing counsel to sign your consent timetable, which means they need time to get instructions. And of course, their clients are on holidays. So really, diarize for 4.5 years is what I would say. And that's my tip.
Excellent. Ted, how about you? What is your top tip?
I would say set an electronic reminder in your calendar the moment you open a file, and invite your support staff or your associates as needed. So never leave any file without some kind of notice of what's coming next, so it can't slip off your radar entirely.
All right. And last but not least, Katie, what's your top tip?
Mine is trust, but verify, also known as don't believe the client. Check the dates and information provided to you by the client. You can do so through resources like police reports, hospital reports, if they're personal injury sort of things, or even title searches.
Excellent. I did see a few people raise their hand on the Zoom. If you do have a question, just a reminder, you can put it into the Q&A box. So there is a button at the bottom that says Q&A. And if you type it in there, we will either try to answer it in the box itself, or I will try to put it to one of the speakers as we go. Moving on, though, we're at our third topic of the program. And we're going to talk about file maintenance and organizing your file. So Katie and Ted have some very helpful discussions and information on that subject. So I am going to hand that off to them now to give us a discussion on that. Thank you.
Thanks, Sean. I'm just going to start out with talking about the general sort of claims we're seeing, and specifically that LAWPRO has seen an increase in ineffective assistance of counsel claims. And those types of allegations are on the rise against lawyers, and in particular within the areas of criminal, immigration, family. And we've actually now started to see them appear in civil matters. These sorts of allegations or claims are largely fact-based allegations that can be refuted and defended by a well-maintained file. While my comments and Ted's herein are about file maintenance, they apply to just all areas of law and just not claims of ineffective assistance of counsel. The starting and ending place when responding to any allegation or assertion against you is your own file. Most cases, as I indicated, are very fact specific. For example, I see things or allegations like, you didn't meet with me. You didn't tell me this. You did not prepare me for that examination. You did not tell me we were going to trial. I did not know that. It wasn't explained to me. These types of allegations are fact-specific claims and are rebuttable if you have a well-documented file. For example, letters and phone calls to you by appeal counsel or counsel taking over a file from you are often the starting point of these allegations. Those clients will generally, those counsel will generally reach out to you and ask questions about your former client, like, did you meet the client in person? Do you have notes and documents or memos to file relating to an event or a meeting? Did you obtain written instructions? Do you have notes on the election or mode of proceeding or trial? These are just a few of the examples of questions that are red flags, and you should be reporting to LAWPRO right away, as there's a good chance that there's an allegation of ineffective assistance of counsel or another allegation that might be proceeding your way. If your file lacks notes, memos to file, and or contemporaneous notes, then it leaves it to be opened to be asked, did it happen? We have been successful on allegations or assertions made when we can demonstrate things did happen, and here are the notes or documents to substantiate that. The lack of notes and letters, we also tend to find cause judges and other triers of fact, like tribunal officers, to potentially have less confidence in you and possibly side with the claimant. Triers of fact particularly like contemporaneous paper documentation. A tip that we use and we articulate a lot is have a retainer and use it. It should have a clear scope. It will set out who the client is, what the scope of the work is, who's giving you instructions, how and why. For example, is it done by email, by text? Where can you send documents to a client? Setting out terms in the retainer agreement establishes what is to be expected and can also state and how the retainer will come to an end. I encourage you to go to our Practice Pro site. We have lots of resources and draft retainer agreements for you to review. Another quick tip is to use dockets and use them to set out a chronology of the work. Also put a short description in your dockets as to potentially or to what the work is that you did. When I say notes, don't just say I met with the client. Refer to what you met about. and the length of the time. For example, if you were discussing the defendant's offer to settle and received instructions to reject it, then use this as an aid. Make those notes. You can also refer to that note or docket when writing a self-protection letter to the client, which can be an essential tool later down the road if you're facing allegations that are being made against you. I encourage you to send reporting letters. They don't have to be long and detailed, but they do have to be succinct and deal with the issues. Confirm dates with your client that they are to attend court or other proceedings. Send interim and final reporting letters, and use technology and dictation and other resources to make this easier for you. I encourage you to regularly review your files, write self-protection letters, set out options, risks, recommendations, possible outcomes, and the consequences of those so that your client is aware. Manage your caseload. If you are overwhelmed or you have too much going on, then you can't dedicate the time needed to each client file, and that is where things will start to get worse or problematic. Another tip I encourage you to do is run a file list and make sure that you know what is going on each file and that you have reviewed each file regularly. For us, when I work with Ted, we always say it starts and begins and ends with your file. I'll turn it over to Ted now to add to some of my comments. Ted?
Thanks, Katie. So I want to build on some of the things that Katie was talking about just moments ago and focusing on ineffective assistance claims. So IAC claims think of them as their variations on a number of common themes. And Katie already mentioned they're typically fact-based. It usually goes something like this. My lawyer didn't listen to me or take me seriously. My lawyer never replied to me. My lawyer didn't do any work. My lawyer didn't tell me that, which was one that Katie already noted. And all this is building to the outcome that the client wants to be able to say, for whatever reason, the outcome of what happened in my case, it's not because of me. It's because my lawyer didn't know what they were doing or they didn't do their job. It's typically one of those two things. So when we investigate on behalf of LAWPRO, the first thing we're going to do, like Katie said, is we're going to look at your client file. So the way I'm going to break down my comments is I'm going to talk about why your client file is important, and then I'll talk about a couple of the key ingredients that we like to see in them. And some of them Katie's already mentioned, and I'll just expand upon that a little bit. Your client file provides me as the investigation counsel with a truly objective snapshot of what happened with your client. So in many cases, imagine like months have gone by since the key events or the alleged error took place. After I speak with you and I hear from you what happened, I take my understanding of the case and I test it against your file. So I look at everything like Katie mentioned, from your retainer letter to your intake notes, your emails, your letters you sent to your opponents, the documents you prepared, and even your dockets and your billing letters. And the goal is I'm trying to figure out what happened. I'm trying to assess whether there's an actual risk of liability if the matter progresses to a claim. Because remember, at that point, when you're dealing with me and Katie, there's just an allegation. It likely hasn't gone to a claim yet. We're trying to find objective evidence of the facts. And this is further to really two things. We're trying to find an off-ramp to see if we can keep the matter from causing or aggravating any of the alleged losses that the client thinks they've suffered or may have actually suffered. And then when possible, we want to try to prevent a complete breakdown of your relationship with your client, unless for whatever reason that's just become impossible. And then in the end of my investigation, I go back to LAWPRO and I advise them on the issues of potential liability, potential damages, whether real or hypothetical, and what steps may still be available to stop the bleeding, for lack of a better way to put it. So in many of these cases, the errors are minor and they're easily repaired. Sometimes I can repair them and sometimes I just help you repair them. But in any scenario, we have to do this with the fully informed instructions and consent of the client. So I need to see from your file what the client knows and didn't know so that we can give them a proper report and make sure that the instructions they give back to us are fully informed. There are going to be cases where we can't do a repair. It happens. Sometimes the error is just too serious or too prejudicial, and we have to shift to trying to mitigate the client's situation before they suffer even more losses or truly irreparable losses. But in either case, Whether we try to repair or not, here are some of the common things you're going to see us do. There's going to be most likely a reporting letter to the client. And depending on the relationship you have with the client and whether it's still intact, you might have a meeting with them as well. If we've determined you're in a hopeless conflict, we're probably going to recommend that the client get independent legal advice. In some cases, if you've made an error and we're all satisfied that it was a true error, you might provide a letter or an affidavit in an effort to try to help the client restore their situation, because sometimes the best repair, frankly, is just getting in front of the issue before it becomes a real loss-causing event. And then in the end, like, remember, an error with no consequence, which is the thing that Katie and I are always going to be trying to look for if we see that there's a case with a true error in it. An error with no consequence, it still sucks. It feels terrible, but it can be dealt with fairly painlessly. So don't beat yourself up if you missed a deadline. Don't beat yourself up if there's been a minor error. It happens to everybody. Get in touch with us so that we can help you stop it or repair it before there's something truly irreparable that happens. But as you can see from those common steps we're going to take, it's critical that we have a clear picture of what happened on the file. So your file is going to help us ascertain whether there's been an actual error. Just because someone says you missed something or did something wrong, that doesn't mean you did. Just because a client lost their case, that doesn't mean you failed to serve them. You don't want to be in a situation where you alone are trying to explain to me, or worse, explain to a judge what happened. You don't want to be the one telling me that your client is difficult, telling me that they ignored your advice, or they were non-responsive, or that they didn't know what they were talking about. I've seen it all before. I know I'm usually confident you're exactly right, but you want your file to be the thing that does the talking for you. Second, your file is going to reveal the strengths or weaknesses of the allegation against you. So just as an example, if part of the client narrative against you is they could never get a hold of you, or that you refuse to take a personal interest in their file, or you improperly delegated, I'm going to look at your meeting notes. I'm going to look at the notes that you sent not only to the client, but also to your colleagues, which probably demonstrate that you turned your mind to the client's issues in direct response to the suggestion that you weren't paying attention to their file. I'm going to look at your dockets. I'm going to look at your emails. I'm going to look at the red lines that you added to work product, things that the client doesn't even realize exist. All of that is going to help me form an assessment of the allegations against you and whether they have any objective weight. And this is different from ascertaining whether there was or was not an error, or whether I'm going to help or not help. I'm going to help you pretty much no matter what. The purpose of this is to help Katie and I gauge how strong your position is, where it might be vulnerable to attack, and where a client or their new counsel may actually be taking liberties with their allegations against you that can be rebutted by an independent documentary record of what actually happened. So it's crucial in giving me those pieces that I can use to push back on the allegations against you and keep the other side honest. And then lastly, looking at your file is going to help me assess whether you have a conflict. And that's really important, because if you're in a situation where you're essentially going to be trying to repair your own error, we can't let you do that. We're going to take steps to have someone take over the file or give you advice on options to present to your client so that we can avoid the situation getting worse. But again, looking at your file, for example, in a case like, let's say, where a deadline is missed, I can tell whether the deadline was missed because you tasked it to someone else to handle it and they dropped the ball, or if you just forgot to do it altogether. And of course, for the purpose of liability, it makes no difference, right? You're the supervising lawyer, so all of this flows to you. But it helps me as your investigation counsel to assess whether having you continue on the file is going to place you at the risk of having to repair your own error. So to sum up why the client file is important, it protects you. And it protects you whether you made an error or not. It helps LAWPRO do its job, and it helps me advise both of you. So keeping a client file is essential. And now I'll just talk about the sort of second part of my comments, which is the ingredients of a good file. And Katie's already touched on a lot of this. A written retainer agreement, which Katie mentioned, ideally signed by the client. The retainer is really crucial, and parts of it can be boilerplate. But when it comes to the details of your engagement, I would advise be case specific. Set out exactly what you're agreeing to do. For example, are you agreeing to proceed to litigation on behalf of the client, or are you agreeing to just assess their case and provide an initial opinion? A lot of people don't distinguish between these things in their retainer because they just think one sort of follows from the other. But it may be appropriate, depending on what the client's issue is, to make it very clear in the retainer. I'm going to assess your case and give you an opinion about what your options are, but I am not committing at this time to necessarily bring a claim on your behalf. That's going to protect you down the road if the client alleges that they were waiting for you to do something and you never did it. Similarly, always be clear about who is or who is not your client. Having a written retainer agreement will immediately help Katie and I figure out who it was that you owe your professional obligations to. And believe it or not, it pops up a lot in our work where we see there's sometimes confusion between the client and the lawyer as to who the client is. Sometimes the client is under the impression that the lawyer has a broader scope of responsibilities to more people than just themselves. But when the retainer speaks to that, it kills that ambiguity and it makes it much better for us to give you advice and for us to assess the liability. And also it protects you from someone suggesting that maybe you failed to do something. Document in your retainer how the relationship ends. Again, this can be boilerplate language, but you want to make it clear in your retainer that certain things will result in the retainer being at an end. And you want to set out how both yourself and your client can end the retainer if they elect to do so. Be mindful of limitation issues. So if you're dealing with a case that has imminently approaching limitation issues, consider whether you want to add a caveat in your retainer warning that certain claims may have expired or are about to imminently expire. My practice is I actually warn clients in writing that my office won't be able to act on instructions to, for example, draft a pleading without at least a week or two of notice. That way I know that if they leave something to the last minute and then they send me an email the day before the limitation period saying, oh my God, issue a claim immediately, I won't find myself jammed up. And I get to say to them, no, I was very clear with you. If you're going to have me issue a claim, I need notice to do that. Now we're going to try to do it, but you don't want it to be left where the client says, you never told me you needed time to issue a claim. I thought you could do it the same day. You have a duty to stay on top of these issues. So I don't want you to think that putting some magic language in your retainer or sending a letter is going to save you from this automatically. But if you leave something ambiguous, you could find yourself on the hook for an issue that you never realized was yours to deal with. So that's why the retainer and specific details in the retainer are so important. Notes, as Katie said, obviously notes are huge. They not only demonstrate that you were taking steps in respect of the file, meeting with clients, maybe meeting with experts or third parties, sending instructions to your colleagues, but they paint a picture for me. They show me what you felt were critical issues on the file for the client, and it helps me gauge what the client's expectations were, and it also helps me understand what your instructions were. And building on that, of course, is all client and matter-related correspondence. Please keep it all, especially emails. This helps us track the chain of communication, helps us follow instructions from the client, which usually line up with your notes in a well-maintained file. It will show me most, if not all, of the documents that you received from the client, because as we all know, clients love to send us absolutely everything they have attached to emails and just hit send. And they think once I hit send, Ted's read it and that's all I have to do. But having that collection of emails and all those attachments helps me get an idea of what was actually given to you to work with on that particular file. Shows me your interactions with opposing parties. Again, helps me gauge your client's expectations, what they thought you were doing, what they told you to do, what you were reporting back to them. And it helps me to place your work product in a timeline, because of course, hopefully the one thing you have kept is all your work product. So I take the documents you were drafting, I look at the emails that you were sending, I look at the notes that you were taking and the dockets you were reporting, and it all sets out for me this chronological snapshot of what was happening on your file. And I'll go to my last sort of important ingredient. Katie already touched on this, dockets. In so many cases that we have worked on, I've gone back to the insured's dockets to help me fill in gaps with note-taking, with meetings, emails, letters, you name it, even work products sometimes. And think of it like this. Client alleges that you rushed them through a critical meeting. You didn't chat with them for even 5 minutes. I look at your notes and I see, 3 or 4 pages of notes that suggest you had more than just a perfunctory meeting with them, but you didn't write down anything that details the timing, start or end. Say there's no emails about the meeting either, but you put a 0.8 in PC Law or Soluno. Well, now I've got something I can work with. And when I'm talking to you about it, I'm saying, well, you billed almost an hour on this matter. Was the meeting 5 minutes? And you say, actually, no, I remember that. That meeting was closer to an hour. And it's just a contemporaneous record that helps me
go through your notes and help jog your memory so that you can explain to me what was happening in that meeting. And of course, if the meeting was an hour long, the suggestion from the client that you were ignoring them really doesn't hold up very well. So in wrapping up, let's just like take those ingredients of a file and apply them to the variations on the IAC claim theme, right? My lawyer didn't listen to me or take me seriously. Your notes, internal and external, your emails, internal and external, and your retainer. All of that file information can directly respond to that type of IAC claim. My lawyer never replied to me. Emails, again, and I'm not just looking at whether you were emailing the client. I'm going to look at whether the client emailed you. Because of course, if the client is saying, I never talked to Ted, he was impossible to get a hold of, but in your file, I see that the client was never actually trying to get a hold of you. Well, that's a fairly important detail for me to see, because it is not uncommon for clients to misremember that they actually only emailed you once. You wrote back to them a couple of days later, but for whatever reason, they got it in their head that you just never answered them. And they thought they emailed you all the time. The dockets, again, did you speak with the client on the phone or maybe over Zoom? And did you put a 0.2 down in your dockets? Well, that can fill a gap for me when I'm trying to figure out whether or not the client is being accurate in saying that you were impossible to get a hold of. If I see 25 phone calls docketed in PC law, that's fairly persuasive evidence that you were not ignoring the client. The next one, my lawyer didn't do any work. Again, show me the work product. I'll look for your red lines. The client may not even know that you were doing all that work behind the scenes. So when you keep it, you share it with me, it helps us build a much better snapshot of what was actually happening. And of course, correspondence will respond to that as well, because if you're writing to the other side, if you're taking steps, clearly you were doing some work. Again, the client may just not have an appreciation of that. And then of course, the classic, my lawyer didn't tell me that. Emails, notes, dockets, correspondence. So the best advice I got when I was a junior at Stockwoods is one of the partners said to me, whenever you receive a critical instruction from a client, note it in your docket entry. So you take, the client says, yes, go ahead and issue this claim. So in the 0.2 that I'm recording for the email that I received, I'll put right in my docket entry, email from client, read claim, claim approved, proceed to issue, period. That is just one more piece of proof that demonstrates that I got that instruction and helps me recall if I ever have to go back and get in an argument with that client or their new lawyer about what did or didn't happen before our relationship broke down. And so that's really it, right? It all, the client is trying to say, the outcome's not me, it was you. You did your job wrong. Well, no. If I look at your file and your file shows that you were working, 9 times out of 10, it provides me with more than enough ammunition to respond to an IAC allegation. And we are successful in responding to many of them. And lastly, on this topic, just because it's noted in our agenda, illness, burnout, and file transition in an emergency. Coming out of COVID, we're seeing a lot of illness. We're seeing a lot of burnout. It's natural. We've had 2 or 3 just kind of awful years that's really starting to weigh on people. A good file, if you're suddenly out of action and someone else to pick up the ball, it can be the difference between a smooth transition and a nightmare transition. And just think of it, it basically does all the things that Katie and I do if we're coming in to look at the matter after there's an alleged error. Imagine you're doing a 1-page transfer memo with the following headings. Who's the client? What's the case about? Where are all the key documents saved? What stage is the case at? What steps have been taken so far and why? And how long until the next deadline? That's a 1-pager. And if you have a well-organized file, you can answer all of it in a matter of minutes. The person who picks up your file will be in great shape. Katie, unless you have anything to add, those are all my comments on file maintenance.
I think I'll just add quickly, because there's a lot of myths about LAWPRO and our role. I just wanted to make sure that you know that simply reporting to a matter to LAWPRO doesn't trigger your deductible and levy. So don't delay in reporting claims. I think, and probably Ted can agree with me, that we like to get the file sort of at the beginning when there may be a potential issue coming down the road. Like I said, if you have a appellate counsel picks up the phone and starts asking you tough questions, report it to LAWPRO, because Ted and I are a resource that you can rely on to assist you in dealing with those sort of tricky situations.
Thank you so much, Katie. Thank you, Ted. Moving on, I'd like to ask all of the other speakers to turn on their video, because once again, I'm going to go around and ask everyone what their top tip is, this time in terms of file maintenance. Katie, I'll start with you. What's your top tip for file maintenance?
I think Ted and I mentioned it quite a bit today, and probably everybody else on this presentation will, but docket, confirm your instructions in writing, document that you have asked for instructions and you haven't received them, send letters confirming instructions.
Excellent. And Ted, what's your top tip?
Oh, I can, people are going to get really mad at me for this. File all your emails. Sorry. Yeah. Sent or received, internal or external. If you can get in that habit of putting all matter related emails in a folder, ideally in a document management system, it's so helpful if there's ever a concern about your handling of the file. File all emails.
Thanks. And Dan, how about you? What's your top tip?
From a limitations perspective, particularly if you are practicing in personal injury, plaintiff side work, especially motor vehicle accidents and occupier's liability, document every single step you take to investigate the claim. Nothing makes an uncertain discovery argument more uncertain when you cannot prove what steps you took and when in order to identify the identity of potential defendants.
And Michael, how about you? What's your top tip?
My tip is RV Trout. That's a case in which the Court of Appeal indirectly tells criminal practitioners the four most important things you have to document in any criminal trial, or you're vulnerable. The Court of Appeal tells us there are 4 decisions only your client can make. If the lawyer makes the decision for the client, it's potentially a reversible error, which means you need to be able to prove that your client made the decision. So what are those 4 things? 1, how to plead, guilty or not guilty. 2, election of mode of trial, jury or judge alone, that's got to be in there. 3rd, whether to testify or whether to risk cross-examination. And 4thly, whether to advance the defense of criminally not responsible. Those have to be in every criminal file. You got to write those down. We at LawPro love signed directions. They can't be beat. I get a warm, fuzzy feeling when I see them in a file. Usually means smooth sailing ahead. Second best is the confirming letter. 3rd best, email exchange. 4th can be a memo to file. And 5th, the docket entry is great as well. I'll take anything over he said, she said.
Thanks so much, Michael. Now, Ted, I think we have a couple of questions that build on what you said. So if you don't mind taking a minute now, maybe to respond to them. The first question is, where a signed retainer agreement is inconvenient for the client, would an email from them stating that they agree to the terms of the agreement suffice?
Yeah, I think it's case specific, right? We all know that retainers can arise in a number of ways. They don't have to be in a formal engagement letter signed by everyone. So I think if for whatever reason that is what is not like, let's not stop at sort of convenient, but if it's appropriate, if that's the appropriate way for your client to confirm their understanding of what it is that you're going to do, so be it. I would just say, like, look at it as, is it clear objectively what it is that I'm agreeing to do and what I'm not agreeing to do? And if an email with a reply from the client saying, yes, I agree to that, gets it done, I think that's okay.
And then the second question, Ted, is the expectation that all revision work is documented by way of track changes? So would it be sufficient that the dockets then explain the time spent on the revisions that are documented through those track changes?
If I understand the question correctly, yes, I think it's appropriate if the way your practice workflow operates is when you edit a document, you record it in your docket, but you don't necessarily make a redlined second version of the document. I think that's okay. In a perfect world, if you're making multiple versions of a document before you get to a final, I would just say save those drafts somewhere, because relatively speaking, the cost to store them online is like nothing. And just having those drafts is good evidence of what you were doing. But if your practice is to record what you do in your dockets, that's okay. You're not required to redline.
Thanks so much, Ted. So moving on to our final topic of this program, we're going to talk about some technology that advocates use. Specifically, we're going to be talking about how technology can lead to breaches of privacy and the claims implications there, and then perhaps some of the newer technology that we're seeing that might be a little bit of concern, such as AI. So to start off, I'm going to throw this to Katie and Michael, who are going to talk a little bit about the kind of claims that LawPro is seeing in terms of breach of privacy, how that can lead to some sort of risk.
Thanks, Sean. Yeah, Michael and I see a wide range of matters coming into LawPro that fall under the possible privacy breaches. And they include the following, but are not like limited to these sort of examples. Misfiled or lost documents in general. This can range from lost disclosure if you're a criminal lawyer, to lost client files, to when you're moving offices and you've lost files or boxes of documents. It can pertain to couriers and courier packages containing confidential files to the wrong address or to the right address, but never being delivered or received by the recipient or client. And now the client or the recipient wants to know where the package is. Emails by way of auto address to the wrong people. For example, I could type in Michael, meaning it to go to Michael, my colleague, and it goes to another Michael. Clearly a privacy breach issue. Accidental Dropbox access to unintended parties or to files that should not have been in that particular Dropbox. Loss of client data on portable devices, such as laptops, cell phones, and USB keys. We see a lot of those being reported. It also can pertain to sending a client documents to the wrong address after the client has notified you of a move, or mailing an account to an address that belongs to the client, but the client has clearly indicated that you are only to communicate to them by email. For example, if the account goes to the household, but other people in the household didn't know obviously about the retainer, that's a privacy breach and can cause you have to report that matter to LawPro. And in general, just sending emails, as I said, to the wrong email address, that with or without attachments, that can certainly be things that ought to be reporting to LawPro. Of course, then we have to ask ourselves what results in that. And I'll turn it over to Michael to talk about the consequences and next steps in those sort of claims.
Thanks, Katie. So yes, this arises in many different contexts, but it's the theft scenarios that always make me feel so sympathetic for lawyers. The lawyer suffers a break-in and is then made to feel as though they did something wrong. And now they have heightened obligations. And that's just the world that we live in now. In the good old days, these were just things that were unfortunate. But we have privacy legislation, and it's been in place for almost 2 decades now. And they set out consequences for when a privacy breach occurs and defines what it is. And the first and the most significant is the obligation of notification. LawPro has to look at whether the client needs to be alerted. And most often, the answer to that is going to be yes. I still remember when the only jurisdiction that we ever knew of that required this was California. And we all thought they were just hippies back then. But flash forward 2 decades later, virtually everywhere, most privacy regimes have some variation of an obligation of notification. If you expose someone, they have a right to know. And that is a difficult letter to write. And it's something that LawPro can help you with. Secondly, a lot of our lawyers are going to want to be provided with some guidance as to whether their particular personal circumstance has given rise to some kind of an obligation to alert one of the privacy commissions, provincial or federal. And that typically involves a review of the level of risk of harm. And that's a professional obligation that LawPro doesn't itself ever instruct any lawyers. That's a decision the lawyer has to make for themselves. But we may be able to assist by giving you some information as to what the obligations are and what level of harm that we're perceiving. One point I did want to make before I turn this over to Ted, who's one of our experts, is to note the effect of encryption. Once a plot device for spy movies, encryption is now pretty commonplace, and it is very helpful in data breach cases. And a lot of situations where the data is encrypted, many authorities will treat encrypted data as a whole other categories, and in some cases as no breaches at all, because if nobody can access it, then nothing's been lost, which means encryption can save your bacon. And I'm oversimplifying it, But a data stick which is fully encrypted, it might be nothing more than a lost piece of plastic. So that is the great news that's out there. So let me turn it over to Ted, and he can tell you a little bit more.
Thanks, Michael. And yeah, just on the topic of encryption, and we don't have a lot of time for all this. So you can actually do encryption the easy way. Just make sure you have the professional version of your Windows operating system, certainly Windows 11, and I think even Windows 10. In fact, I'm sure Windows 10 come equipped with a program called BitLocker, which will help you encrypt USB keys and the hard drive of your host device. I'm happy to talk to people about that offline. There's all different ways you can do that. But like Michael says, that can cause a lost laptop to be not a thing at all. So I would strongly recommend everybody become familiar with encryption. It's not complicated anymore. Privacy breaches, look, this could be a standalone topic. We've actually done CLEs on privacy breaches and taken up the entire hour with it. But what we're going to do today is I'm just going to try to, I've got about 5 minutes. I'm going to run through the steps that we would typically take in any privacy breach case, whether it's a serious one like you got hacked, or it's a minor one like you left a paper file at a coffee shop for 20 minutes. The first thing we're looking for is we're looking for personal information. So forget privileged. Imagine privileged is at the more severe end of the scale. We're looking for any factual or subjective information that might identify your client. Anything that has to do with where they live, where they bank, their passport number, their credit card number, their credit score. If there's information like that got out, even for a couple minutes, we have to do an investigation. When we investigate, there are essentially 3 steps, and we're going to do these 3 steps in varying degrees of, again, severity, depending on how bad the breach was. Step 1, we're going to investigate to look for containment. What kind of information got out in the open? Is it still out in the open? How did it get out in the open? And again, not for the purpose of blaming you, but for the purpose of trying to conclude whether the cause has been identified, because that's going to be very important if we get to a reporting situation. And then why it got out in the open. So this is different from how. This is to get an idea of whether there's an ongoing security breach or a temporary one. And if it's a temporary one, has it been addressed? Step 2, we evaluate the risk. We want to figure out whether there is what's called the real risk of significant harm. And this is defined in legislation. Bodily harm, humiliation, damage to reputation or relationships, loss of employment, loss of business or professional opportunities, financial loss, identity theft, negative effects on a client's credit score, damage to or loss of property. These are things that can constitute harm for the purposes of a privacy breach. Then we try to figure out there are 2 factors that will apply to our assessment of whether there is a real risk of significant harm to your client. We look at the sensitivity of the information. So like medical records and financial account information, it's very sensitive. A date of birth or a phone number that isn't already publicly available, maybe in isolation isn't sensitive, but if it's part of a broader portfolio of the client's identifiers, it actually could become sensitive. And then we consider what's the probability of misuse. So who accessed the information? How long was the information exposed? Is there evidence of malicious intent? The number of pieces of personal information breached, was it high or was it low? Has harm materialized for any of the affected individuals? For example, has someone had their identity now stolen and a line of credit opened in their name? Has the information been recovered? And whether the information was easily acceptable, i.e. was it protected by encryption, as Michael noted? So if it was encrypted, that will militate against a probability of misuse. Third, notification. We notify relevant parties. If there's a real risk of significant harm to a client as a result of a breach, you're going to notify the Office of the Privacy Commissioner by submitting a breach report. You have to do that as soon as feasible. I'm happy to talk offline with people about what is typically included in a breach report, just because I want to be mindful of our time. Outside of the privacy realm, though, turning back to so now we're talking about privileged information. You may, in some circumstances, also have an obligation to report to the Law Society. That will happen if the breach and the loss of information has resulted in the possibility that your client's interests are likely to be severely prejudiced. So, disclosure of solicitor-client privileged information, that will usually carry with it a significant risk of prejudice. Whereas personal information, what I was talking about earlier, especially personal information that might already be in the public domain, that may not. So you have to consider whether the affected information has relevance to the merits of usually an ongoing legal proceeding. That would put the scale up to the higher level. Of course, not all breaches will require reporting, as Michael noted. You can always choose to report out of an abundance of caution, even when it's not mandatory to do so. But if you do have a breach of your safety protocols for any reason, even if it's for a few moments, contact LawPRO. As Katie said, there's really very little harm in making the report. The sooner we get in, the sooner we can take our investigative steps, and we can try to help you deal with the breach and ideally head off greater damage. Sean, I hope I brought it in on time there. I'll stop so you can keep us moving.
That's perfect, Ted. Thanks so much. So our last topic, which is going to be short because we just want to give a cursory overview of this, is we want to kind of breach the subject of AI. It's in the news right now. There are risks associated with this new technology. Everyone's wondering, what can it do? Are we obligated to use it? Are we obligated not to use it? And there might not be a good answer to that everyone wants to hear, but I'm going to throw this right back to Ted. And Ted, if you could give us a brief summary of what AI means for advocates and lawyers, what things like ChatGPT do and how they can be incorporated into practice, and whether that's a good idea. I'm going to throw it to you.
I will do my best. Okay. So again, unfortunately, this isn't going to be the big AI seminar that I think everybody wants to have, because AI is so interesting right now. But I think you can view AI as emerging in two areas relevant to law, okay? E-discovery and then standalone large language modeling, and I'll sort of explain what I mean by that. In the context of e-discovery, artificial intelligence is being used to conduct doc reviews. So imagine if, instead of just searching for keywords like we're all used to and trying to find a batch of relevant documents that way, you have a machine-driven search that can be trained to look for concepts. So in other words, the machine reads all the words in your production database with the ability to understand sentences, and then it turns out relevant statistics back to you and tries to identify relevant documents, finding the highest percentage of hits that it thinks are relevant to the concepts you're interested in. So imagine if the machine can find documents that don't use any of the keywords you thought were material, but it's still able to help you find documents that are relevant to the concepts you're dealing with in your case. So for example, there are products on the market that are pre-trained to help identify a toxic work environment as a theme. So it doesn't need, you're not basing it on keywords. It knows what to look for if it's looking for indicia of a toxic work environment. Other companies are working on development tools that can find evidence of deception or fraud, again, by actually reading the database and communicating with you identification of concepts. The idea is that if the model is trained correctly, you can grind through a huge amount of data with relative confidence that you're finding the truly responsive material, and not just be limited to, I'm looking for keyword A or keyword B. This is sometimes also known as TAR, T-A-R, or technology assisted review. The e-discovery experts, and there are many of them around the city, they will be able to speak to this in much better detail than I can. But the other big thing right now seems to be large language models. And this is where you're hearing all the buzz around ChatGPT. This was heavily fueled by the emergence of this platform called ChatGPT, launched by a company called OpenAI. GPT stands for Generative Pre-trained Transformer. And it's basically, it's a type of language prediction model that uses machine learning to generate human-like text. Quite simply, you can have a conversation with a machine, and it feels like you're just talking to a person. ChatGPT is an artificial-driven large language model that you can have these conversations with. So you can ask it, ask it a question in sentence form, and it'll give you an answer in sentence form. Its answers are based on a huge amount of data that was ingested into it that cut off in September of 2021. So it doesn't know anything after September 2021, at least not yet. The company OpenAI itself has not specifically disclosed publicly what the data sets were that it used to train ChatGPT, but we know that ChatGPT was trained on, quote, a diverse range of internet text. And if you want to know how I learned any of the stuff I just told you, I asked ChatGPT and it told me. So it's really as simple as I have to do a lecture on AI. Can you tell me what ChatGPT is? And it will give you all kinds of information in response. Whether or not it's accurate or true is another problem. So for lawyers, as you can imagine, this kind of technology is very attractive because you can quickly obtain information in a conversational format. So you could write an essay if you were still a student. You could get a summary of a famous book, or maybe even a not so famous book. You could write a policy for your office. You could write facta. Now, I wouldn't recommend that you just go to ChatGPT and say, write me a factum on equitable trust in Ontario, because there are problems. The platform, and anyone who uses it will know this, doesn't have a real ability to signal to you that it may have misunderstood your prompt. Prompting is what we say when you put a sentence into ChatGPT or any chat language model for an answer, you're prompting it. So, for example, a colleague of mine was telling me yesterday he had asked ChatGPT who authored a well-known cross-examination text from like 1960. And this, of course, fell within the range of ChatGPT's ingest, so it has an answer. And the author it came back with did indeed write a cross-examination text, but not the one that had been the subject of the prompt. So it'll give you an answer, but it may not be accurate, even though the platform is quite confident when it tells you that it has the answer right. And this is where we get the concept of what are called chat hallucinations. And this is probably what you read about. A number of lawyers got in trouble because they filed with the court briefs about cases that didn't exist. So if you ask ChatGPT what a chat hallucination is, it will tell you, quote, in the context of chatbots and language models like myself, a chat hallucination refers to instances where the AI generates information or statements that are incorrect, nonsensical, or not grounded in reality. Essentially, the model hallucinates details or facts that did not exist or are not accurate. And this can happen for various reasons, such as the model misinterpreting the context, having been trained on imperfect data, or trying to complete sentences in a coherent manner, but missing the mark. So AI, here are just some warnings. It's super cool. It's undoubtedly going to revolutionize the way we do business. But if I could just be the killjoy here, I think that at this point, it's something that you should familiarize yourself with so that you understand how to deal with it and work with it, because it is a really great tool, but don't rely on it. You can't rely on it too heavily yet. The day will come when it will replace legal researching, I think, but we're not there yet. So in addition to giving you inaccurate answers, I want to just caution you about privacy risks. In the fall, Microsoft is going to be releasing a ChatGPT-driven plugin for your Office 365 platform called Copilot. Copilot is basically advertising itself as having ChatGPT integrate itself directly into your Office 365 platform, read all your stuff, and help you go about your day. Product's not out yet, but on Google, there are already a number of imposter products advertising themselves as browser plugins that will give you the power of, quote, ChatGPT in web browsing. These products are not to be trusted. They are not made by OpenAI, Microsoft, or Google, many of them, and we should be concerned about what their providers are going to do with the prompt information that you put into them. It's like inviting a third party basically to follow you around on the web. So I'll just offer a couple of AI warnings for the early adopters. As of right now, play with ChatGPT, have fun with it, but don't trust it. If it gives you something helpful, verify it independently, or you could find yourself reporting to LAWPRO. Don't share confidential or privileged information with any chatbots, including ChatGPT, and beware of imposters. Don't download any third-party plugins for Chrome or Edge if you haven't looked into them first. And if you really want to have an AI-assisted web browsing experience and you're okay with the sort of reduced privacy expectation that comes from that, Microsoft Bing offers a chatbot that integrates in with your web browsing experience and your Microsoft account. And I think Chrome has something similar. But again, please don't ever reveal confidential or privileged information in those chats. Thank you, Sean. I think I made it just barely.
Should we record the time spent on a file when it's a flat fee matter?
Such a good question. You know, you don't have to, because you're not, the time is not what you're getting paid for. If it makes sense for you in your workflow, in your practice, what you could do is just keep the dockets detailing what you did each day. But again, if your practice is not to keep dockets, as I know many practitioners don't because they don't have to, I'm not telling you have to do that, but think of maybe your docketing system as something that just records what you did, even though you don't particularize the time.
Okay. And Ted, because I have you, one more question. Is there any Macintosh or Apple equivalents of BitLocker that you know of? You spoke to that on Windows 10.
That's a really good question. I don't know because I'm not familiar with the very latest Apple OS. You could probably look up any of the free archiving and encryption programs. They will be OS compatible, and you could use them to encrypt files. As for your actual hard drive itself, I actually don't know. I'm sure there is. I'm just not familiar with what it might be, but I'm sure there is some tool that you can use to encrypt your actual hard drive on an Apple device. I apologize, I just don't know.
Okay. So there are a couple of questions asking about the CPD credits. So just a reminder to everyone who attended this program that this is worth 90 minutes of professionalism CPD. It is a proof of that. And as well, it is good for one RM risk management credit from LAWPRO, which is worth $50 off of your next year's insurance. So you can claim this program when you claim your RMC credit. One last question. We're at time, but hopefully we don't go too far over. I'm going to put this to Michael because he just joined us in video. Michael, is there a potential claim against a lawyer if a bill is outstanding and the lawyer has advised the client that no additional work will be done until the bill is paid?
Well, that'll teach me to turn my camera on. God, yes, absolutely. We see this, unfortunately, too often. The classic scenario is client stops paying, lawyer writes to them quite clearly and says, I'm not doing any more work until I'm paid, so you understand. Lawyer does nothing, client does nothing, action then becomes administratively dismissed. Lawyer says, hey, I told him I wasn't doing anything. Client says, yeah, but you didn't tell me that I was at risk of administrative dismissal or any of the other bad things that happened while my file was just sitting in abeyance. So if you're going, the correct thing to do, of course, is you got to get off the record. You can't leave yourself sitting on the record of a file that's vulnerable to all these bad things that happen when it's stagnating. The other thing you can do is you can write a letter to the client saying, here are the things. I'm not taking any steps. So that means I'm not responsible for the limitation period, which, by the way, will be this date. So the short answer is yes, unfortunately. It's not fair, it's not right, but that is what it is.
Thanks so much, Michael. So we do have a couple of comments from people who are attending the program who say that File Vault is the Apple equivalent to the program that Ted was speaking to on Windows 10, And so you might want to check out File Vault for your Apple program. Just a reminder that this entire program will be available to rewatch within approximately a week on practicepro.ca/CPD. It's also where you can find all of our old and previous programs, including last year's top tips for advocates, which contains different material and different tips. Thank you again to all of our speakers, Ted, Katie, Dan, Michael. This was an excellent program. I learned a lot, I know. And thank you to the TLA for helping us organize this. If you want to find any of the materials, they are in the chat. They're also on the practicepro.ca/CPD page. You can also find precedents for retainer letters at practicepro.ca/practiceaids, practice-aids/precedents/retainers, or you can search for that on the Practice Pro page itself. Unless there are any other questions, I want to thank everyone for attending today, and I will just refer this back to the TLA to wrap